Good morning, this is Attorney Vincent W. This is Get Your Kids Back Now. This show is dedicated to keeping families together and fighting CPS and DCFS social workers. A secondary purpose of this show is to educate parents and relatives, or to at least show them where to get the necessary information for their fight. The final purpose of the show is to remind the people that change can be effectuated at the ballot boxes, at the state and federal levels. Let us unite, vote, and elect those who will make the necessary changes.
So the social worker has to complete this paperwork called SDM, which is Structured Decision Making. And that's a program all through California. It's basically a cheat sheet for the social workers. You fill in the blanks, add everything up, and it will tell you whether you should take the child or not. That has to be filled out. And then the child and then the social worker has to write the detention report. Now, this is the fun part, because social workers have a tendency to exaggerate. So you have to really watch what you're saying. You know? So that's basically it on temporary custody. You have to know your rights. That's one reason I'm talking to you about this, because social workers will lie to you. They'll come and take their children. They won't give you the appropriate paperwork, and you're left wondering what I do. They just give you a thing and say, show up to court this day, this time, and that's it. And then once that's done, social workers generally won't talk to the parents until the report is finished, and then court. And the last thing is that you are by law supposed to get a copy of the report by mail prior to the hearing for you to review. They don't always do that, so be careful.
Terry, let me ask you a question. Are you saying that as a parent, if you detain my child today, and let's say my arraignment detention hearing is going to be on Tuesday or Wednesday, are you saying that I'm supposed to have a copy of the detention report and or petition before I go to court?
Yes. You are supposed to, the social workers, as soon as they're done writing the report and it's approved, they have to mail a copy out to the parents.
Well, the way it works in LA, I think. First of all, the attorney and the parents never get a copy of the detention report and the petition until the morning of the detention hearing. As a matter of fact, I don't think that the social workers even file the petition and the report until the morning of the hearing. Is there a law or a state policy that requires the detention report and the petition to be served on the parents before the detention hearing date?
Child Protective Services, any of them, are reactive rather than proactive.
Right.
In their policies and procedures. And I think something happened, and there was some kind of lawsuit or something, and then all of a sudden, we were always supposed to do it, but we didn't. And then all of a sudden, we got a memorandum that said, you have to do it. Be in compliance.
That's very interesting. It's always been something, a pet peeve of mine when reports and petitions aren't served in a timely basis. But I'll give you an example of something that happened to me maybe 2 months ago. I appeared at a detention hearing representing a mother, and about 10:30 I got the petition with the detention report and the exhibits. It was maybe a 1/4 inch thick. At 11:30, the bailiff came out and asked me, hey, are you ready to do your case? I think the judge wants to do the case. And I said, well, I'm not ready. You've given me, a quarter-inch worth of paperwork. I haven't even read all of it. I haven't gone over it with my client so that we can try to prepare some type of defense for the detention hearing. And, the bailiff looked at me like I was crazy. We didn't do that case until the afternoon. And here's what happened. The judge did detain the child and then set it for a receipt of report date and a trial date. Now, the receipt of the report date was, as you know, Terry, for the jurisdictional and dispositional hearing report to be turned in.
Right.
And the receipt of and I forget the exact dates, but it was like this: the receipt of the report date was on Monday, the trial was on Wednesday. And I kind of objected. I said, look, if I get the report on Monday, I won't even be able to subpoena the witnesses that I will need for the trial date by Wednesday, let alone start the trial on Wednesday. And the judge gave me a couple of extra days, but it was like, I think the statute, I haven't looked at it, requires that report to be maybe 5 or 10 days before the actual trial. Like, how do you get a report and with that's going to be an inch thick and go to trial 2 days later? You haven't even had a chance to review it. You haven't had a chance to review it with your client. You haven't had a chance to subpoena witnesses. What are you going to do? Subpoena them overnight and tell them to be there, the next day? They're going to be pissed off, or they're going to make a motion to quash that subpoena. So, when I bring these types of little things up, it seems to be disturbing the way that business is done sometimes in these courts. And, I get funny looks. Nobody ever says anything, because I think deep down they know I'm probably right. But I do get these funny reactions. And that's always been a pet peeve of mine. Now, I'm going to confess something. After 31 years as a lawyer, I did not know that the petition and the detention report were supposed to be given to the parents before the detention hearing. Makes a lot of sense to me, but I've just never seen that done. And I've done cases in a lot of different counties. I've done many cases in Los Angeles County, and that is, I will say that has never happened for me or my client. Never. It would help if you were given the paperwork a day or two before, but that's not how the counties operate. And the more I'm thinking about it, if you come up with the authority in the policies and procedures or in the law that says they should be getting it a day or two before the hearing, I'm going to consider bringing a lawsuit about that issue, because nobody does it. It was like, all of the counties were detaining kids for decades without, a court order or a warrant. And then, Sean McMillan down in San Diego says, hey, scratches his head and say, hey, this is unconstitutional. And he brings a lawsuit to now require people to do this. Had he never brought that lawsuit, I don't think anybody would have ever thought about it.